Injustices, the Supreme Court's history of comforting the comfortable and afflicting the afflicted. I'm Chelsea Alford, and this is Bookmarks. Hello, and welcome to Bookmarks. I'm your host, Chelsea Alford. The Supreme Court has long been a target of criticism in the United States. Its major decisions are well known: Dred Scott, Brown versus Board of Education, Roe versus Wade, and now Obergefell. But the court has also shaped American jurisprudence through many lesser-known decisions, from criminal justice to economic policy. In his new book, Injustices, Ian Millhiser of the Center of American Progress argues that the court has historically been biased toward those who already possess power. Mr. Millhiser joins us today. He is a senior fellow at the Center for American Progress Action Fund and the editor of Think Progress Justice. He clerked for Judge Eric L. Clay of the United States Court of the Appeals for the Sixth Circuit, and has worked as an attorney with the National Senior Citizens Law Center's Federal Rights Project. And joining us to critique the book is Lawrence Alexander, the Warren Distinguished Professor of Law at the University of San Diego. He is co-executive director of the Institute for Law and Religion and co-executive director of the Institute for Law and Philosophy. He teaches and writes in the areas of constitutional law, criminal law, and jurisprudence. Gentlemen, thank you both for joining us.
Thank you.
So Ian Millhiser, can you give us in a nutshell the main thesis of your book?
Sure. I mean, the thesis of it is that the Supreme Court's history has been fairly dark for almost all of that history. You know, the early racial history of the Supreme Court is well known. It's Dred Scott, it's Plessy v. Ferguson, which upheld segregation. It was many, many years of doing little or nothing to intervene in the Jim Crow South. And while all of that was going on, it was also, the court was coming up with very creative ways to limit the rights of workers, to limit the rights of people who were not very well off. And so the court struck down minimum wage laws. It struck down laws that were intended to prevent people from being overworked. It struck down child labor laws. What scares me, and I mean, I'm happy as we, you know, because there are some periods in the Supreme Court that we look upon with praise. I'm happy to get into in a sec why, like, first of all, I think that era was an anomaly, and second, why it was less good than people tend to think it was. But I'm worried when I look at our current court that we seem to be on the cusp of returning to the past. And
Lawrence Alexander, what is your critique of the book?
Well, when I read the book, I was expecting a detailed critique of the Supreme Court's jurisprudence. Instead, what I found in the book was a dissatisfaction that the Supreme Court has not interpreted the Constitution and particular statutes to be in line with progressive policies, which struck me as an odd critique of the court, since the court's job, as I understand it, is to interpret the Constitution according to its meaning, and the Constitution itself is largely an 18th century, late 18th century and mid 19th century document, and it's completely unlikely that the people who wrote the document intended for it to endorse the policies of the left wing of the Democratic Party.
I'd like to remind our audience that you can submit your questions to our guests through our website, www.publicsquare.net, and we'll answer as many as we can live on air toward the end of the show.
But I thought it was very important to tell the history of the Supreme Court through the eyes of the people who are often the most hurt by it. And so that was an intentional decision. That said, I mean, most of the content of this book should not be controversial today. You know, I mean, obviously, as I get closer and closer to the modern era, I'm going to be discussing cases that are still contentious today. But I spent an entire chapter discussing a case which struck down federal child labor laws. That is not considered the notion that that case was wrongly decided is not considered a contentious issue today. You know, I spent a whole lot of time in there discussing the development of the court's race jurisprudence and how the court for many years stood with segregation. I think it is not considered contentious today that racial discrimination is both wrong and unconstitutional, and that when the words of the Constitution says something like Congress can regulate interstate, or Congress can regulate commerce among the several states, or that no one shall be denied the equal protection of the laws, those words do indeed have a particular meaning, which were inconsistent with the decisions that the court handed down.
Well, let me respond in two parts. First, I think you misunderstand my critique. Whether or not most people agree that a certain decision was a bad decision or not a bad decision, whether certain decisions were regrettable, the way to critique the court is to take the court's interpretation of the Constitution, the arguments it gives, the arguments that were marshaled against its interpretation, and see which is the most persuasive. When I take up, you're referring, I'm sure, in the child labor, you're referring to Hammer versus Degenhardt, which was decided in the first quarter of the 20th century. And while Hammer versus Degenhardt was, of course, overruled, finally overruled in 1941 in U.S. versus Darby, the arguments about the interpretation of the reach of the Commerce Clause in Hammer versus Degenhardt were not frivolous arguments. And the idea that Hammer versus Degenhardt should be characterized as the Supreme Court essentially endorsing child labor, which was not at all what the decision was about. The decision involved child labor, but it was a state law that allowed child labor, and the question was whether the federal government had power under Article I to ban the products of child labor moving in interstate commerce.
You know, where Hammer came from is about 3 decades before 1918, which is when the Hammer case was decided. The words of the Constitution that were at issue there was where the Constitution says that Congress can regulate commerce among the several states. And the court created this distinction between the transit and sale of goods, which they said was commerce, and therefore Congress is allowed to pass laws regulating the transit and sale of goods, and manufacturing, agriculture, mining, other things that are essential to commerce. They said that that actually was not part of commerce, and so Congress could not regulate that. And so on the surface, what the Hammer v. Degenhardt decision was about was it said, well, child labor is about manufacture, it's not about sales, it's not about transit, therefore this isn't commerce, so we're going to strike it down. Except that the law was very cleverly designed in order to get around that problem. It didn't actually ban child labor, it banned the transit of goods that were produced by child labor. So Congress followed the rule that the Supreme Court had created for them, and what did the Supreme Court do? It changed the rule. You know, this is what I think is the problem from the decisions of that era. And this is why I do think it's fair, frankly, to pin a certain degree of intent on the justices. Because when you look at how they behave, this era is often referred to as the Lochner era. They would create doctrines and they would apply them very selectively. So yeah, I'm happy to pin some blame, not just some jurisprudential blame, but some moral blame on the justices here, because you have to wonder why they weren't following their own rules.
Well, look, we can get into the question. I'm perfectly happy to say that I find it hard to reconcile Hammer with Champion versus Ames, the lottery ticket case, which was decided several years earlier. And as you know, one of the problems with Supreme Court doctrine is that to the extent that the court is divided, changes in personnel produce changes in doctrine, and those changes are very difficult to plot. And so that's not, you know, there's no argument that Supreme Court decisions can be criticized.
Right.
But I think for example, you spend a lot of time criticizing Citizens United, as if, you know, the decision dealt, you know, was only to sort of aid plutocrats, as opposed to a free speech opinion, which also helped labor unions, because the law affected labor unions as well as corporations. It doesn't. None of the critique deals with the Supreme Court's First Amendment arguments. So you might disagree with them, but you have to disagree with them on their terms.
Well, let's be clear. I think that billionaires buying elections is a bad idea, no matter who they're buying them for. So it doesn't matter if Democrats or Republicans are benefiting. I do say in the book that there's a lot of empirical data showing that Republicans have tended to benefit more from Citizens United. And now, I mean, Citizens United is a fairly recent decision. We'll see if that data continues to play out as we have more elections. But with the little bit of data we have, you know, it does seem to be a decision that has benefited Republicans more than Democrats. I also spend a considerable amount of time discussing the errors of doctrine, of First Amendment doctrine in the Citizens United decision. The cornerstone of our how the Supreme Court has thought about campaign finance law since at least the 1970s is that campaign finance is something that is protected by the First Amendment, and that's probably a good idea. You know, we don't want, when someone is buying ads that are, you know, for the purpose of influencing the way people think about politics, we do want to be cautious about having the people who are themselves running for election regulating that too much. But what the Supreme Court has also said is that if we don't have a way to regulate money in elections, we have to, then you have a problem with corruption. You know, then you have a problem where people get bought, and you know they start trading away favors. The logic of Citizens United is that the only thing that really counts as corruption, this is the core holding of Citizens United and of some of the court's subsequent campaign finance cases, is that the only thing that counts is what they describe as a quid pro quo deal. If I say to you, you're a lawmaker, and I say, here's $1 million, and if you want this $1 million, you have to cast a vote a certain way. Mm-hmm. And I think that's just a naive concept to think that that's the only way corruption works. You know, I think it's, you know, you brought up Sheldon Adelson. Governor Romney, you know, Sheldon Adelson is someone who, the reason I pick on him in the book is because he was the most generous donor in the 2012 election cycle. He donated over $100 million to candidates that he supported. Governor Romney had 2 private meetings with Sheldon Adelson, and you know it's possible they were discussing, you know, they exchanged photos of their kids, and it's possible they spent that time talking about their favorite sports teams. But I suspect that the reason why Sheldon Adelson wanted to meet with Mitt Romney was because he had some ideas about policy. And I also suspect that the reason why Romney was willing to listen to him, and was probably eager to listen to him, and probably thought very hard about those ideas that Mr. Adelson had, is because Mr. Adelson had been so generous. And I think that that's corruption too. There doesn't have to be an explicit deal. Subtle influence is enough.
I'm not going to be, you know, in this thing trying to defend Citizens United. But what I'm saying is that you have to take the Supreme Court's reasoning, and of course, you know, remember that Citizens United was a nonprofit corporation that ran some video about Hillary Clinton, and the notion that, and that was illegal under the campaign finance laws as they existed at the time. And so it seems to me that when you talk about corporations, You have the New York Times is a corporation. There are all sorts of corporations, and they have views that they want to spend their money in private citizens like Sheldon Adelson, like George Soros, like Tom Steyer. They have views that they want to spend their money promoting. Now, there's no question that politicians need money to run their campaigns, and so they're going to pay attention to people who are willing to give them money, and that may be a problem. But the First Amendment basically protects speech, and it doesn't say that you can only speak a certain amount, and that if you speak too much, you can be silenced. And so I think the basic notion of the Supreme Court is that if people want to spend their money endorsing ideas, endorsing candidates, that's a legitimate way to spend your money.
Yeah, I don't know that I necessarily disagree with that. I mean, yeah, if people want to spend their money, you know, to help, I mean, I've donated to candidates before. That is a legitimate thing to do. The problem is that there's also a countervailing interest there. You know, this is a two-sided issue and not a one-sided issue, where on the one hand, if you have too much regulation of campaign finance, then you do have a very dangerous situation where the people who are elected are deciding the rules for how the elections are going to be run and who gets the money that they can mount a successful campaign. On the other hand, if you have too much money kicking around in the system, it leads to corruption. And the court's jurisprudence, at least since the 1970s, when modern campaign finance laws started to became a thing, the court has recognized that there must be a balance struck between making sure that people's free speech rights are protected, while at the same time protecting against the very dangerous thing that is political corruption. The problem with Citizens United is that defines the notion of corruption so narrowly that the word basically means nothing. I do want to also riff off of something you said at the beginning of your remarks, Larry, which is you're right about what the case was actually about. The Citizens United was at the time this nonprofit that I think few people had ever heard of. They produced a movie that was critical of Hillary Clinton, and they wanted to show this movie on pay-per-view. And yeah, the idea that the FEC would go after some company that wanted to have a pay-per-view movie was dumb. I mean, the FEC shouldn't have brought this enforcement action against this nonprofit. And I think that there was a very strong statutory argument to be made that this wasn't what Congress had in mind when they passed the campaign finance laws. They didn't mean we should be banning pay-per-view movies that people voluntarily look out for. The problem with the Citizens United decision is they took what could have been a very small and very simple and very easy case, and they turned it into a sweeping declaration about not just the rights of corporations and unions to spend money on elections, but the nature of what corruption is and the scope of the law's ability to prevent corruption from existing in our elections. And that, if anything, I think that is as much of an indictment as the decision as anything else, is that the court was presenting with something that they could have decided very modestly. They probably should have decided very modestly. It probably could have reached the same result if they decided it very modestly. And instead, they blew it up. And in the process of making it this huge case, they said some things about the nature of corruption, which I think don't match up with anything that anyone would think about how elections work.
All right, well, let's take some questions from our viewers. First question is from Nicholas Banks. He asks, in the cases you cite, did the business interests never have the stronger argument?
I mean, sometimes the business interest does have the stronger argument. I mean, I think it would be a ridiculous position to say that there will never be a case in front of the Supreme Court that a business interest should win. I also think it's the case that through much of the Supreme Court's history, the court has not just favored business interests in a way that I think is hard to square with the the best reading of the Constitution, but that, as I've said, they've often manipulated their own doctrines. So the most egregious period, as Larry and I were going back and forth with about a little while back, was the early 20th century, where they'd say, like, okay, you can regulate the transit of goods, but not really in this one instance. Or, they said that you could have a maximum hours law for women, but not for men. They said that you could have one for minors, but not for bakers. And I mean, they were drawing really arbitrary lines. And so, I don't think that an appropriate way to look at the court would be to say that there's always going to be a big guy and there's always going to be a little guy and the little guy should always win. I do think, but I do think that when a court is acting in a way that appears to be arbitrary, that's a very serious problem. And when they've been acting in a way that appears to be arbitrary for a good chunk of their history, possibly most of their history, that's a very serious problem. And then when they've been acting in a way that's been arbitrary for almost all of their history, and it turns out that for almost all that time, the people who are already the most well off tend to get the better end of it, that I think makes it all the more egregious. But I think it is the arbitrariness of so many of the decisions I discuss in the book that makes them so deeply offensive.
Let me just point out that while there's been lots of criticism of the decisions in the Lochner era, and even back in the Lochner period, so let's just take the Lochner case itself. So one way of representing it, the way that it comes across with in Mr. Millhiser's telling of it, is that this was a decision in favor of business interests against the little guy, the baker, and who the law was trying to protect by limiting the maximum hours that the bakers could work. In fact, as a lot of history of that particular case reveals, that's a very simplistic portrayal of what was going on. Indeed, a lot of the bakeries, one way of looking at it is this was essentially a law that was favoring large bakeries over mom and pop baker, typically or other ethnic groups, immigrant groups, who ran little bakeries where cousin Luigi would mind the ovens, and he'd sleep most of the day, but it wasn't something where you could set it up on 10-hour shifts the way that a large, Wonder Bread could set it up on 10, the sort of industrial bakery could do this, but not the little mom and pop. So there are lots of laws that look like they're there to protect the little guy, but actually what they're there to do is protect some well-organized business interests against some other business interests that are not as well organized and is not as powerful.
Our next question is from Elaine Franklin. She asks, what do you recommend to fix the Supreme Court?
It's a tough question. I mean, like, if we had the power, if the Constitution were easier to amend, there are a number of states that have independent judicial selection committees that I think do a better job of producing less political judges. And so, that would be an amendment that I would support. I think that part of the problem, frankly, is that the Constitution is very vague. The Lochner decision that we keep going back and forth about, what that decision said is that there's a line in the Constitution that says no one shall be denied liberty without due process of law. And the court read those words, no one shall be denied liberty without due process of law, and they said, and they said, well, we're going to read into those words this notion that the government can't decide what contracts, or at least the government's ability to decide to regulate contracts between workers and employers is very, very limited. Now, I mean, to your point earlier about the notion that Lochner, whether it was about big bakeries or small bakeries, there was no evidence in the court's opinion that that's what the court was concerned about. And the court did not hand down a narrow decision saying that in this case we think this is really protectionist legislation, and so we're going to strike it down on that narrow grounds. They struck it down on the very broad grounds that in all cases there will be a tremendous amount of skepticism when the government tries to regulate the labor relationship. They did that based on words in the Constitution that I think can't really be read, you know, unless you stretch really hard to have that meaning. And I'm sure you'll point out that those same words in the Constitution form the basis of the court's Roe v. Wade decision. I am critical of the logic of the Roe v. Wade decision in the book. I mean, I think that Justice Ginsburg has made a strong argument that that reproductive rights are implicit in the Equal Protection Clause of the Constitution. The notion you can't discriminate against women in this case. But I think that courts should not be taking the vaguest words of the Constitution and reading rights into them that are very hard to find in those words.
I'm not sure that independent commission would be a good idea. I'm dubious that independent commissions are superior to the current system, but that's really a side point. I do agree with Mr. Millhiser on this. I do think that substantive due process is probably a mistake. It was but a lot of decisions like Roe versus Wade and Obergefell are based on the same reading into the term liberty without due process of law, what the judges think that should mean.
Okay, that's all we have time for. Again, the book is Injustices, the Supreme Court's History of Comforting the Comfortable and Afflicting the Afflicted by Ian Millhiser of the Center for American Progress. Thanks to Mr. Millhiser for joining us to discuss the book, and to Lawrence Alexander of the University of San Diego for his critique. And thank you for watching Bookmarks. I'm Chelsea Alford. We'll see you next time.